This is Lacey Turner versus Michael Turner. We have Mr. Blumberg present on behalf of Ms. Turner, who's also present by Zoom video. This is set today for a show cause hearing. Mr. Blumberg, I did review your show cause motion. You're alleging that Mr. Turner's violated the prior order of the court by disposing of assets and essentially moving assets or putting them out of the reach of the court's order. Anything that you wanted to state for the record on that?
Yes, Judge. Besides the violation of the order for trying to dispose of assets, he was required by that same order to pay all of the household expenses that he historically has paid. And the fact of the matter is he's failed to do that. We have quite a list of things that he was required to pay that he has not paid. I think it's relevant for the court's consideration today is that Mr. Turner apparently is going to trial on either in the next week or two on delivery of methamphetamine. So I don't know how that impacts on where we are today, but clearly a condition of his bond is that he not violate any laws of the state of Michigan or any orders of the court. And it's clear to me that he has done that. So we're prepared to go forward and explain to the court through my client's testimony of what bills he's not paid, including rent for the last 8 months. And yet he's conducting business. He has his own business and he's chose not to use that money to support his family. There's also a temporary child support order that he's not paying. So clearly he is willfully defying the orders of this court.
All right, in terms of the disposal of assets, what are you asking the court specifically to order with regard to that or the non-payment? I mean, if the court were to find Mr. Turner in contempt, what's the remedy that you're asking for? Because I suspect what he's going to say is that he doesn't have the money to pay the household bills because of his other matters. And that's one issue. The other issue is the disposal of assets. So what if the court were to find he's in contempt, what are you asking me to do on those issues?
Well, I think the court would fine him, perhaps incarcerate him. These are all things that are within the discretion of the court in a contempt proceeding. But perhaps even more importantly than those two things is that we believe he does have the money. He's collecting money for jobs that his company's doing, and he's not performing the work. He tells the Michigan State Police that there's some trust account in which he's holding these funds. Those funds, if they exist, would be available to meet his obligations under the court order.
Okay. All right, thank you. Mr. Turner?
Yes, so I'm going to deny hiding any assets. I haven't transferred any assets since the motion was filed on 4/25. I believe what they're referring to is the Durango that my company previously owned. Turner Handy Home Services began its wind down period 3/31, and with doing so, I disposed of the Durango that's in question. I sold it, and then I dissolved the company 4/22, which was 3 days prior to Mrs. Turner filing for divorce. I have been financially unable to pay her bills because my company dissolved. I was forced into homelessness on 3/1 when she filed a PPO. My company collapsed as a result. I've pretty much been unemployed all year. I was certified homeless on 5/10 by NEMSCA. They assisted me in finding an apartment on 5/24, and NEMSCA has paid my rent until 10/31, just until last month. I just started a new business, 9/18. I'm kind of getting things, going with that. There was a child support order that was put into place, awarding arrearages back until May for a total of $5,298.50. As of November 1st, I did pay my child support plus arrearages in the amount of $1,110. Over the course of the summer, I was doing some odd jobs here and there, and I was able to make a little bit of money. And I sent whatever I could. I sent money on 4 different occasions for a total of $800.
Okay. All right. Mr. Blumberg, any response to that?
Well, Yeah, certainly, if Mr. Turner felt that he couldn't comply with the court's order, it would have been incumbent upon him to seek relief from the order. He's never filed a motion to relieve himself of the obligation that from the order that the court signed. The fact is, there's two young kids involved here that are not receiving child support from their father, who's otherwise physically able to work. You know, I've heard this excuse from the beginning of this case. We understand, again, that he is represented to the Michigan State Police that there are funds available, that those funds are being held in some trust account. Again, I don't know if that's truth or just pure sophistry on his part. In the meantime, it's these two kids and my client that are the ones that suffer because of Mr. Turner's refusal to support his family.
Okay, well, I mean, first of all, I guess there's two different issues. Well, there's three different issues here. Number one, the child support issue. That's a matter that would, I'm assuming that's through friend of the court. Is that right, Mr. Blumberg? Is the child support order through that? I doubt that.
Yeah.
Okay.
Yes,
So the enforcement mechanism for child support would be through the friend of the court, and to the extent that that's not occurring, you know, I'm sure that friend of the court is following that part of it because they've got an obligation to. In terms of any bond violations in the criminal matter, I think that's something that would need to be reported to the prosecutor's office for determination of whether they would seek an ex parte order to revoke bond. What is, I think, appropriately before this court is the court's order that was entered, which did prevent the disposal of assets and the requirement for payment of household expenses. So I think in order to make a determination about whether to what extent Mr. Turner should be held in contempt on that, I think the court would need to conduct an evidentiary hearing. Number one, I would need to determine this issue of when the Durango was sold, who it was owned by, and there's also Mr. Blumberg in the messages that you attached, which I think we would need to have an evidentiary basis to admit, but assuming that they were admitted, there's also an indication in there that there was $8,000 that was also moved to avoid, specifically to avoid the divorce, because that's in that text message. I moved this because somebody told me to get it out so that it wouldn't be part of the divorce, which would clearly be a violation of the court's order if that's true and if that is admissible. But I think the court would need to make evidentiary findings on that to hold Mr. Turner in contempt for the Durango and or that $8,000 or any other assets. So I'm going to set this for a 2-hour evidentiary hearing. Mr. Turner, to the extent that you have documentary evidence as to those issues, you're going to need to bring that to the court. It's unlikely that just denying it is going to provide sufficient weight. You're going to need some documentary evidence. So anything that you have to defend against these claims, you're going to need to bring to that contempt hearing. And then, Mr. Blumberg, obviously, you'll bring the evidence that you have.
certainly.
The court will set that for a hearing date and notify the parties of that. Mr. Turner, you've been raising your question. Do you have a question?
I just wanted to clarify a little bit about the messages that were attached. The $8,000 was a communication between my client and I. What had happened is, obviously, I made some mistakes in my business. I was given an $8,000 advance from my client, who then subsequently fired me from the job, and they did a chargeback on their credit card, and it pulled that $8,000 from my account, leaving my account very, very negative, and that's what led to the dissolvement of my business. So that $8,000, I never actually, I had it for a short amount of time, and then it was taken back.
Yeah, that's fine. I mean, I understand that's your position. You're going to need, like I said, to bring some documentary evidence showing that that's what actually occurred, which there should be some evidence of that.
There is.
Paper.
Yep.
So that's how we'll proceed on that. The court will set that for the soonest date possible, because I know timeliness is an issue here. In terms of proceeding with finalizing the divorce, because this was also set for a status conference here today. I know we've got these issues outstanding, but Mr. Blumberg, how do you envision us getting to a resolution here?
Well, there was a hearing in front of the referee. I don't know that Mr. Turner filed an objection to the recommendation or not. Certainly, again, how this criminal matter turns out, again, whether he's going to trial, I looked at the court's docket, it looks like it's coming up fairly soon. That's going to obviously have some impact on the ultimate custody and parenting time.
Right, okay. I'm going to set this for a status conference at the time of that contempt hearing. And let's see where we're at that point and whether or not the other issues have been resolved. Mr. Turner, is there anything that you wanted to put on the record regarding scheduling to resolve the divorce matter? I mean, at some point, this divorce is going to need to get finalized.
Yeah, I mean, I don't have any withstanding issues. I'm not sure why this is being drug out so far. We've hashed out child support, custody, all that. I've offered to give Mrs. Turner to the Durango if that's what she wants. I don't really want to fight about this anymore. I'm just ready to wrap it up. You know what I mean?
Okay, well, then I would suggest that you get in touch with Mr. Blumberg to see how that can happen.
I would if you would return my phone call. I've reached out probably a dozen times to no avail.
Okay. All right, that's all I have for today. The court will send out notice of the date and time of the contempt hearing as well as the status conference, and we'll go from there. All parties are free to disconnect.
Thank you.